mitigation one?
Hmm?
The mitigation one?
No, the one for the public hearing, the 2019-9. That's the one.
Okay, it's 1:30, we have 6 here.
What you have before you today actually starts with your adoption of Ordinance 2019-9 on May 20th, effectively the Rural 1, Rural 5, Rural 20 zones, and the district use chart. The subject of your amendments was the multifamily allowance allowed in the density sections of each of those zones. In the ongoing discussion of the comprehensive plan and the zone code, the commissioners have the language in the density section, the language of accessory dwelling. So the commissioners, in identifying that as being anomalous with the language of the comp plan as adopted in 2014, and certainly in the language in the proposed of these amendments, without public hearing, you're required to hold one within 60 days. Your public hearing today is within that public testimony portion of the hearing. Your interim controls progress and are prepared to move ahead with some sort of permanent amendment to the respective code, in this case your zone code. What will more likely happen here is these amendments will fold into the review of the zone code, which will necessarily follow the adoption of your revised comprehensive plan. We anticipate that will be within the 6-month window. The matter will then go to the Planning Commission for review, in addition to whatever other amendments to the zone code seem appropriate. If in fact we run up against our 6-month window, we'll schedule another public hearing. You have the option of assigning that task. So whether the Planning Commission will be in their own public hearing process at that point, or whether we'll need to schedule one separate from that remains to be seen, depending upon how the schedule goes for review and adoption of the comprehensive plan. In broad strokes, that's why you are here today. Why don't you go to the specific language? Previously, you were allowed to have five-unit multifamily structures per acre in each of the Rural 1, Rural 5, and Rural 20 zones. If you do the math, obviously in a Rural 20 zone, you could have arguably 25 five-unit complexes. And in discussion with members of the advisory committee that worked on that, and I haven't talked to all of them, but those I spoke to actually believe that was probably a Scribner's error. It came about through the cut and paste effort that inevitably is part of the review of this kind of regulatory document, and that wasn't necessarily the intent. At any rate, it is anomalous to the other language in those particular code sections. So in where you would demonstrate the site's ability to provide potable water, on-site septic treatment, or as part of a sanitary system, as part of a water delivery system, that would be the purpose behind the conditional use permit. In the other zones, now Rural 5 and Rural 20, they're not allowed. So your district use chart amendment simply parallels that. They're now a conditional use permit in the R1 zone and not allowed in the R5 and R20 zones as currently adopted. Any questions of staff?
Why is that exactly?
Oops. Well, the district use chart does show amendments
Well,
consistent
I
with
can
the
flip
text.
it.
We can, oh, there you go. We can go there and prove that to you.
It's the only question I could come up with at the time.
Very good, very good.
Wait a second. There we go. Wait, why is it?
You're actually beginning to make me just a little bit dizzy.
Well, me too, so.
I can read them upside down.
Do you want me to send it to you right side up?
No, I think I might, is that what this is? No,
That one's 8.
no.
I have it right here.
If you just go to the page on, that has dwellings and flip it around, that,
Dwelling sales looking for single
all the rest of it can remain topsy-turvy.
Yeah, we only need it up right when we're looking at that page.
So here, look, here's the page here that we're looking at.
Phew. Sorry about that.
So it would remain permitted in the minimum requirement district, remembering that that's the district that we put in place over the Colville Reservation. They're subject to their own regulation and permitting requirements. Conditional use permit in rural 1, and of course the blackened square is prohibited in rural 5, rural 20. All the rest remains the same. So with that, any questions, Commissioner? And I suppose I should highlight, it hasn't really come up in any of the comments, and I actually don't believe we've received any. Farm worker housing in your code is treated separately from multifamily. So if a person was going to put in multifamily farm worker housing, it would be subject to those specific regulations, would still have to demonstrate water supply and all of those requirements, but it is treated separately, and it is a permitted activity, at least at this point, in all zones. None of the actions you've taken have changed that.
Are there other, you refer to other rules that apply to the farm worker housing?
There are, and in fact, many of the farm worker housing projects that have come up in recent history, they've actually permitted through the state.
I have a small question. It might not be anything that we can do right. Why, in the Methow Review District, is multifamily a conditional use permit?
I can't speak specifically to that, Commissioners. That would be a holdover
Okay.
from the previous efforts, the last of which I think was the year 2000. When we went through the 2016 review of the zone code, other than some line adjustments on the map and the neighborhood commercial around the Lamberts or the unincorporated towns and cities, the Methow zoning didn't change.
So
Other
to keep-
questions?
To keep this consistent, we might have to look at that too. How about?
I think certainly, and of course, again, following the comprehensive plan adoption in its final form, the zone code would be next fall. You would have to review it, even if you don't make any changes, you would have to review it under the banner of consistency to make sure that now the zone code would be compliant, consistent with the new comprehensive plan. I anticipate there'll be suggested changes. You've already taken one action under an interim control, which you're looking at today, and you have a public hearing on July 25th to deal with the second interim amendment that you put in place. Those at any rate will need to be looked at by the Planning Commission to determine if they're going to be adopted permanently, if you will, into your zone code. So there'll be some review.
Public testimony? Anybody from the public? Did you sign up? No?
I did.
Okay. Come on up.
Valley in particular, but Okanogan supported this interim measure to water sustainability while giving the longer-term and just to let you know, and we are
Appeal 2019-9, if you believe leaving them in place is inappropriate. You have of amending. If you wish to do that, you would direct me to prepare whatever amendments you believe. Certainly by motion and vote, if you'd like to actually make those specific directions, then that's appropriate. But those, in essence, those are your three options in terms of what you're doing today. If you wish to have continued deliberation, you need additional information from staff, you can certainly continue your public.
Okay, more second discussion. We don't need a continuance.
No,
Is that action?
next item on your agenda, Commissioners, once you can pull up the mitigation language. You'll recall that there has been text in your zone code now authorizes their, prior to that, under division of land, it stated that no applications would be accepted. In review with legal counsel, they suggested that that was unusual to actually not accept the application, and then that was actually my idea to begin with, to prevent a vesting question. They said it would be more, I don't know how to say it, a more consistent approach in terms of how land use permit applications are processed if you simply directed me to not approve them, which is in essence what the ordinance does. So it now states no application for the division of land pursuant to Title 16, which is your subdivision code, lists the variety of ways in which land can be divided, will be approved in these water availability study areas. Now it lists some exceptions. Your public purpose segregation, testamentary provision, which is your last will and testament, conservation easements, your water systems, water rights, those other things, water purveyors. And then there was a discussion of mitigation language. Now this discussion has been ongoing. The Department of Ecology has been involved. When last we had it in front of you, we had some language that you looked at. You directed me to go back and see if I could put more specifics into the mitigation language. So this is not in front of you today in public hearing format or necessarily for adoption. You would have the option, if you wish, to adopt it as an interim control and set it to public hearing. You could transmit it to the Planning Commission for their consideration. How you wish to proceed, you have some latitude. More the discussion today is if we're getting closer to mitigation language that you're comfortable with. And this was my last stab at it. The discussions by way of recap, and then for those who have perhaps entered into the discussion on a fresher basis, the mitigations are directed to those areas now under water availability study restrictions. In the case of the Methow, the restricted areas of the closed basins. In 49 is specifically the Upper Tunk, Lower Tunk, and Tamarack Spring, Huck basins. Arguably, they're applicable anywhere where you have concerns with impairment of in-stream flow, impairment of senior water rights, any place that you have determined that there's water supply issues. So what we're looking at is language, and in many respects it parallels language that comes out of ESSB 6091, now 9094 RCW, for ways to offset the consumptive use of that water. So, and that's what the stab at. It's site specific, both in time and place.
I have a question.
Yeah.
Because I think that we might be able to get somewhere a little, so from what, this is going to be a land use activity. The county is going to be responsible for determining whether the division of land can fall or can be done under this section. So my thought is that if I'm a landowner or anybody else, and I want to drill a well in a basin that has these overlays on it, I'm going to have to come up with a mitigation plan. So I'm going to have to create a mitigation plan, because I'm going to have to tell you how it is that I'm going to achieve replacing the water, basically.
Correct.
And then that mitigation plan, we're gonna have to probably, because DOE said that we could consult with them on, for things like this,
Correct.
okay? So, when this reads, division where the applicant can demonstrate mitigation measures that offset the consumptive use of water, either site-specific both time and place, or on a comprehensive basin-wide approach after consultation with Department of Ecology. Well, so are we going, is the county gonna determine the site-specific time and place without consultation to DOE?
Well, that's how it stands in front of you, obviously subject to discussion. Now, the reason I went that path is because it also includes the question of cisterns, storage tanks, which may be, that's a very, very, very specific use of the term in time and place if you're not actually pulling water out of the ground. And I guess that's your mitigation. The basin-wide approach was, in consultation with the Department of Ecology, comes from one of my last conversations with them. And actually it was an email exchange.
Right.
Where that is their preference, but they didn't necessarily outline what that would look like. The feedback we've gotten from the Department of Ecology was actually more specifically geared towards an on-site, very specific types of mitigation, your on-site infiltration gallery, that sort of thing. The basin-wide approach, we didn't get in as much detail. So while and obviously it's up to you, while I'm relatively comfortable with what the Department of Ecology envisioned as a very site-specific, on-site mitigation sort of infrastructure, I get public health's use of cisterns and tanks, but I also understand their reluctance at this point in doing that. I do not have as firm a grasp on the sorts of things that the Department of Ecology would view as basin-wide mitigation. And obviously that's consistent with the whole discussion around the Hearst-affected basins and the watershed plan updates, WRIA 49 being in the beginnings of that as we speak. So, and the NEB guidelines are out for additional comment and review. So even the Department of Ecology doesn't have an absolute picture of what that basin-wide mitigation would look like. So I thought it appropriate if we were talking about a more basin-wide approach. And that would be consistent with the allowances of 19-27097 subsection 2, where in your non-GMA counties, we have the option of coming up with a plan with the Department of Ecology, and that's specific to building permits, where you can essentially identify areas when there's specific circumstances, the building permit, the policies, the broad strokes policies in place are your proof of potable water supply. So, and then-
So let's just talk through this about the process, because that, I think, is what's been kind of difficult sometimes.
devil's in the detail, I believe is the appropriate
That's why when I
phrase.
read this, I see where, okay, well, if we're gonna do a comprehensive wide basin plan, more than likely, the county is going to put forth something like that. I mean, I don't know do you feel like if somebody who's gonna divide land up would say, hey, if I divide land up, I'm gonna do a basin-wide approach? I wanna mitigate for every single person within the basin?
No, I guess I was more thinking that that would be a front-loaded policy. So, whatever basin you're in, and that language is probably more applicable in 49 where we're actually doing a watershed plan update, that to a point will get to that very specific question. So, using that as an example, the planning unit comes up with a recommendation, initiating government sends it in, that is adopted as an update to 173-549. In those areas, if you do this, you've mitigated your potable water supply, your consumptive use. You're not into then a site-specific review other than making sure you're consistent with the requirements of the watershed plan update. That's
Okay,
49. Now, 48 is a different discussion in that we haven't had even the beginnings of that kind of basin-wide sorts of mitigations, nor is there a watershed plan update scheduled. In that particular, the legislature has now told us that 173-548 explicitly regulates permit exempt wells. Follow your rule. Well, your rule doesn't talk about mitigation.
Okay, so let me just run some scenarios by you. Okay. I want to subdivide my land. I go down and talk to XYZ water consulting firm, and I say, okay, this is what I have, this is where I'm at, and I pay them a bunch of money to give me basically a plan, a design for infiltration gallery, mitigation, blah, blah, blah. Okay, so I say, okay, Mr. Huston, here is my plan that I just paid $10,000 for to mitigate for this, and you'll see it's got a hydrologist stamp on it, da-da-da-da-da. Okay. Now, now I'm Joe Blow and I don't have very much money, and I come in and I say, here's a picture of my 50-gallon drum with a bunch of holes on my napkin that I'm gonna submit to you as my mitigation. I'm gonna dig it down 6 feet in the ground, and I'm gonna pour water in it from somebody. How are we going to distinguish between those two different things as far as what may work and what not? Because you're not a hydrogeologist, nor would I ever try to put that in.
Understood, nor am I a biologist, but I still sign off on permits in the Shoreline Master Program. The codes actually lay out, if you will, what the requirements are for application. And this obviously just opens the door to that exception. We would still need a building official. I don't necessarily look at the blueprint to see if it's how I would build the house. I look at the credentials of who put that together.
Right.
Sure that it passes muster. What I was thinking, my distinction between something that we, the county would approve versus something we do in consultation with the Department of Ecology. The contrast, for instance, would be you have a 4-lot short plat, you want to mitigate the water, you create your on-site infiltration gallery as an example, you demonstrate how you're going to get the water into it, the lawful source, how often, that sort of thing. That's dealt with on a site-specific basis. And wide, we create a water utility. We come up with your infiltration infrastructure, if that's what we're going to do, or the storage reservoir, whatever we've created. You come in with your 4-lot short plat, you pay into the mitigation account or something. You don't come up with a site-specific proposal, you just buy into what is the system-wide, the basin-wide mitigation, whatever that might be. So it's still general language at this point. What I'm trying to do is kind of push aside the site-specific from the basin-wide and try to illustrate what some of those things might be.
I mean, I like where we're going here with, with doing this. I just think that if we said divisions where the applicant submits a water mitigation plan, and then a water mitigation plan is defined as, you need to tell us, timing, where it's coming from, what it's doing, all those things, then we get away from ambiguity, or we get away from the portion where I say, well, I'm a, builder or whatever, and I know that I can put water in a tank and, have a drain out for so many hours at a time or things like that. I mean, it has to be consistently applied if we're going to do
I
this.
understood, I agree. I mean, and you can go so far, actually, I saw Dan. Mr. Higby, can I borrow you from him? The county could go, pull up a chair, join me. The county could go so far as to actually prescribe certain types of infrastructure. Correct me if I'm wrong, there are certain things in the building code where you actually have examples, foundations, that sort of thing. I know in the flood mitigation regulation, you have actual examples of how to build your knockouts, how to build your flood-friendly foundation, so you don't send them off and say, go design one that
Right,
works.
yeah.
You actually have one in the book.
Prescriptive method,
Yeah.
right?
Yep.
So, I mean, we could take that same approach, if that's an approach the commissioners would like to take. A basin-wide approach, where I thought consultation with the Department of Ecology would be more appropriate, I guess the way to say, we can certainly consult with them on everything, but on a basin-wide approach, it'd be more appropriate, because you're not going to deal necessarily with site-specific mitigation. Something else, somewhere else in the basin mitigates for what you project to be your consumptive use from permit exempt wells. Now, we will need a much bigger look at what that might look like, be it one big storage reservoir or one big infiltration gallery that everyone buys into. We can't do impact, that would be part of impact fees allowance anyway, I guess, now that I think about it. So we'd have to probably use SEPA, would have to move ahead with my question as to whether we'd actually form a water utility, a la the cities, where you're not necessarily delivering water through pumps and pipes, but you are mitigating a water system with individual withdrawal. Those sorts of things. That's why on a basin-wide approach, it would be simpler once you get it done, because you're not reviewing each and every individual site-specific
Right.
proposal, but it'd take more work to get there.
Yeah, and I'm not saying don't have that piece in there. Because the county is going to need that piece in there, if we're gonna come up with a mitigation plan. But what my concern is that, individuals will want to mitigate for their building, because you got people that are multi-millionaires that wanna come over here and build a house, they just wanna do it. They have enough money, they can go hire whatever they wanna do, So it has to be where, no matter what, everybody's submitting the same thing to you for review, so that you don't, so we're not saying, okay, yeah, you went and got a hydrologist review, that's great, we're gonna accept that, and then this person didn't, but we're gonna still accept it.
Would the commissioners be inclined to have pre-approved mitigation infrastructure?
Well, it would be a little bit more predictable in terms of what you're going to approve, and this is giving the planning director the authority to make the approval. I think that we should have something relatively defined. We're still in the throes of defining mitigation in 48 or 49, and this is about subdivision, not just about the exempt wells. So I would think that we'd want something more than, for instance, you used an example, Commissioner Hover, about a cistern, but the cistern has holes in it, so it's a recharge type facility. And to me, that has less predictability than just having a cistern that you fill up and draw water out of. You're talking about something with holes in it that
Yeah.
recharges the aquifer.
Right, but I know, from all of the discussions that we've had throughout the state, that is being looked at as an approved form of mitigation.
Yeah.
But I agree with you that if I just have a cistern and I go fill it up and I say, oh, that's the water that I use for my house. If I run out, obviously I gotta fill it back up. I agree, it's more predictable, but here, okay, so here's something that I don't know, is can a cistern be used for a group domestic system?
Yes. We have one.
And in essence, they're water storage facilities. And I think they're used all over, if I'm not mistaken. But
Because that makes it-
they're stored
Big difference,
well, probably.
because if you
Yeah.
couldn't, then, but you could for a wellhead, then you would wanna mitigate with, a recharge facility. Now, here's the other thing too. If we have all cisterns, okay, the water that's coming in has to be potable water as far, it doesn't necessarily have to meet all of the qualifications of a group system. Obviously, you want to be putting clean water. But there are, different regulations for water that's gonna be consumed versus water that's going into a recharge facility.
So I go to conceptually, the overlay that we're talking about is a temporary situation for subdivision. I'm beginning to feel we're a little bit ahead of ourselves on including the types of mitigation that we would have in a 2-year overlay. And that is in existence until we figure out whether there's enough water in the basin to serve more subdivisions. I see what you're getting at in the meantime, is are there options to actually go ahead and do subdivisions? But I'm wondering if we're getting a little ahead of that because of the studies that we're looking at right now in 49. What does mitigation look like?
But we're not even looking at them. We're not even studying anything over in 48.
Right.
So we have 2 years.
So what we have
and then those things go away.
Yeah, so what we have here, then we've identified 2 different issues that we're dealing with the same rule.
But what if, for instance, right now in 49, okay, if I owned a house and said, okay, I know I can come up with a mitigation plan, and I'm gonna buy water from wherever, out of basin.
You own a house.
Huh?
You said you own a house, if I own a house.
If I want to, if I want to subdivide, and I can put together a mitigation plan for all of those plats, or all those parcels, then why should I not be able to do that in the next 2 years, just because on a large scale project type thing we're doing with the watershed plan?
We're talking 48, we're still.
No, we're talking 49.
Okay, we're talking 49. Okay, but we're still identifying those mitigation options, whether they be a single well or a project-wide situation, right?
I don't know, are you?
Maybe going back and to the point of beginning, if you will. All your water availability study areas, you've designated 2 now. The Jess did that to prevent all subdivisions was owners, to use that as a word. So the suggestion was, if we can mitigate where we're going to use, should we be allowed to move ahead with our subdivision proposal?
Mm-hmm.
And the commissioner said, well, maybe. So we've been working on mitigation language that would get us there. I mean, the final analysis is when you finish your study, and in the course, in the case of 48, it's actually mostly, in my opinion, mostly directed at mitigation to try to deal with the surface water closures and the connectivity. In 49, still an impairment issue, but senior water rights more than in-stream flow, although in-stream flow is certainly always part of that discussion. So moral of the story, at the end of 2 years, in 49, we would have had the results of our study and figure out what we're going to do about it. Well, now, since that time, the WRIA 49 process has started. They're working on concurrent pass, so there'll just be some question of coordinating those efforts. They're both on essentially the same timeline. 48, as you point out, there is no such process that has been initiated, so we're working on that on our own, although in consultation with the Department of Ecology, who has opened the door to the discussion of mitigation. So,
Yeah, I mean, one of the things that I think of is on some of these mitigation plans, I'm trying to be specific, because if we just say, go forth and do, it could just end up being the people with the most money get to do it, and the people that don't have any money might not be able to do it, just because they can't afford to do whatever we think they should do. So, I mean, if we have a prescribed way that we're looking at these things, and part of these can be studies. I mean, when we talk about studies, right, the county has to conduct these studies, whether we pay for them to somebody to come do them, or whether we have staff do them. We don't have a lot of resources to do these things. So if we're mitigating in a basin, let's say, and what we're trying to do is keep water in the streams, okay? Well, how do we know if what we're doing is working, if there are no stream gauges in there, if there are no ways to measure the effect of what we're actually doing? And I know that's getting way down in the weeds, but it's still, these are the things that I'm thinking about, because if I were to come and propose to do a mitigation plan, be the first one in any one of these things, I guess the county's first question would be, okay, how are we going to measure the success of your mitigation?
very real question, and in fact, it's kind of the foundation of the NEB documents that the Department of Ecology is still trying to get out in final form. And you might all remember that it was going to come out in final form a year ago, June. So even the Department of Ecology is wrestling with that. I suppose it depends on the comfort level of the commissioners in making assumptions. If you assume or measure so much water comes up and the recharge rate is acceptable to you, and the difference is your consumptive use, and if you put your consumptive use back in the ground from where it came, if you're happy that's mitigation, then I guess we mitigated it.
Right.
Now, I often come up with the idea, if you're pulling your water at 300 feet, but you're putting it back in at 8, are we really even talking about the same water? I mean, does that get down?
And are we actually, if we were to mitigate it that way, would we actually benefit stream flow?
Well, and that's, of course, the $1 million question. Are we I mean, theoretically, we're benefiting somebody, I guess, or at least we're no net loss. But is that water actually in the same connectivity, if you will,
Right.
connected to the water from which you're drawing? So, or should you actually be mitigating your water at 300 feet, which brings up a whole host of other challenges in terms of pumping water straight down in the aquifer and all sorts of other things.
Well, it's important to consider that this additional mitigation language, especially on a short bill app, especially because that's what we do around here, right?
For the most part.
Yeah, and it puts in the planning directors, whoever that person may be, the authority to look at a mitigation plan and decide that it's valid or not. And so there's a bit of speculation that would go along with that. I'm getting that from the conversation we're having. So, yeah, defining what that mitigation is then is important, and there's things that there's other forms of mitigation that might even include just how the lots were subdivided, or landowner might have more than one lot already, there's other mitigation measures that actually just, that zeroes out the newly created lot or lots. So there's those types of mitigation. The ones that I'm trying to get a handle on are those that, again, put in your, as the planning director, your realm of authority, the decision to say that this is mitigation and it works. That makes it a little bit harder. And then the other part of it, of course, is that the difference between the two watersheds, I think, somehow needs to be broken out in this if we go there. Because again, this is a temporary moratorium, if you will, on subdivision. And keeping that in mind, there's circumstances out there that we don't see also that puts a hardship on people that might be very simple subdivision processes that I think we're trying to get at here.
I want to make sure that we are, that we're limiting our liability as far as, how did you come up with that decision?
Yes.
But also, understanding the fact that these things are going on around the state. They exist right now. And so just because we don't know how they work, doesn't mean that we shouldn't go out and be looking at, how they're working in other places.
I think that's a good idea, to go out and see how they're looking, where the rainfall is in those areas, and to make, solid comparisons. I think that's really, that's smart.
Well, I think, I want to do this. I want to do this. But I just want to have a defined process of how it is that, a mitigation plan gets submitted. Because, right now, I know of 2 or 3 different individuals who have talked to me about, hey, we could go do this, or we could go do that, as we talk about mitigation.
I think the rules should be different for 40, or the exception, which I think kind of is an exception, should be different from 48 by 49.
Why?
Because the 2 CFS rule and the closed basins are unique circumstances to the Methow Valley.
Okay, but the water issues over here are the same as over there as far as if somebody didn't have it. Okay, if we were to put a water availability study over there, or area there on a non-closed area of a basin, because people were saying, hey, we can't get water, all this new development came in, we can't get water now. Okay, we'd be doing the same exact thing. So why would a mitigation strategy like that over there be different than over here?
Because of the closed basins, the 2 CFS rule, the Methow Watershed Council, and the work that's been done is different, way different. It's a different world. And so, in fact, if we're eliminating risks, then I see a much higher risk in the mitigation rules that you put in place, or exceptions, than in the Okanogan. The Okanogan is in a watershed planning effort right now to identify mitigation measures. And so I see all these differences, and I think that they should be treated in the overlay. Because here we're reading here where water is obtained from a lawful source of storage. Mitigation plan shall be reviewed, approved by the planning director. I asked the planning director right at this moment, do you see a difference in the way you treat the Methow Valley and the Okanogan Valley today in this circumstance?
Yes. Right now, just as a matter of example, we're actually authorized to repair in stream flow.
Mhm.
in 49.
Yes,
In 48, we don't have to,
right.
as long as we're drawing from the QCFS reserve. So over here, right now, by the legislative directive, we don't pay any attention to in-stream flow.
Right.
They come in and pay their fee, they get their well, except in the water availability study area where we're applying a different question, a different standard, even though they can get the well
Yeah.
for a building
Yes,
permit.
we could. And they have to agree to certain things that, honestly, it would be hard for us to enforce any of that, just as a side note.
I mean, the legislature has created two
Yeah.
different worlds.
Yeah, they have.
And by legislative direction, 48 explicitly regulates permit exempt well. 49 does not. So they told us how to do it in the interim until February 2021.
So we
Well,
have that up.
in terms of an approach, I mean, I hear what you're saying in terms of, who looks at these things and who approves them. And understand this is not another element of empire building. It's just I'm the one that signs a short plat anyway. So
No, that's what, it goes with
it
it.
is the way it works. But that said, Shoreline Master Program has language in it regarding, for instance, your vegetation management plans and that sort of thing. Has to be prepared by a certain credential. Dan, in his world, has, correct me if I'm wrong, has the same issues in terms of steep slopes and engineered foundation. They don't do
Beams,
that.
everything.
An engineer brings in the plans with the stamps.
Right, I mean, I can't go build a house that's not engineered.
You can,
Yeah.
if it meets the prescriptive provisions
So
of
let me ask
the
you, a question.
code.
Can I build a truss that's not engineered?
No,
The truss has to go on the house.
right.
Did. And we can actually parallel that discussion in terms of getting, where the commissioners would prefer to go. If you have your pre-designed mitigation measures in a folder, if you build one of these on your property, we just double check to make sure you built it right. Versus, no, I wanna do something else, well, now you have to go to a hydrologist or somebody else.
So to further this discussion along, could you get in touch with DOE and find out if we were gonna look at site-specific mitigation plans, what would be things that DOE would, if they're gonna, because they wrote us a letter or a note, their email, that said that they were gonna provide us with technical support, then what would they need to look at if we were gonna ask them for technical support on site-specific mitigation?
I will take that one email that they actually sent us, beginning to move in that discussion, and ask them to embellish
Okay.
and see what it looks like.
Yeah, I'm curious, because I'm curious also how the Water Conservancy Board is trained in making decisions on that particular matter. Because it's ecology that provides the training, and it's ecology that makes the final decision, right?
They don't make the final decision, do they? They just review the decision?
Well,
The Conservancy Board makes the decision.
Right, and then ecology just reviews the decision.
and they can say no if it doesn't comply with the law, so
That's
it's the
true.
same damn thing. So whatever, I would consult with them to find out and make sure that we don't miss the point. It's just not the technicality we're talking about here. It's actually ecology trains the Conservancy Board what the law allows them to do. Whether they make the final decision or not is not really the issue, so we don't have to debate that.
Okay. We will do some additional research. I'll bring it back before you.
Because I know that these things have been presented to them before. I've talked to a member before in the past, and they had proposals that were mitigation proposals that basically allowed water to be moved. So I think it's important to ask that question. And if we get a face-to-face with folks here to have a conversation about how health and ecology is looking at these things, I want the Conservancy Board to have a member present so that we know that, there's some consistency in these water rights decisions.
Now, one question, I guess, to say it that way, and then maybe more of an observation. Your storage tanks, your cisterns, however you want to characterize that, I see as a measure employed in an area where you have physical water supply challenges. The on-site mitigation measures where you're talking infiltration galleries and that sort of thing is more a discussion where you have legal challenges to your water supply. That would be mitigation in terms of groundwater recharge, one that doesn't work unless you have a water source to pull it from. So there I make that kind of line between the two, I suppose theoretically. You'd use a water tank in an area where you have a legal challenge to water accessibility. I don't know if public health is more or less comfortable with that. Haven't had that discussion, but just an observation, I guess, that I offer up. In those areas where you just physically can't get the water, obviously you don't have much option, but to tank it or not build.
That's one that needs to be answered because, we've got a lot of wells out there that have storage tanks. I mean, they're all over the place. And they have presumably legal wells that are putting water in the tanks for when the electricity goes out. And for other reasons. And a lot of that it is a legal issue. I mean, it is that, a conversation I have quite often is that if we're a county that can't afford to pay certain salaries and things like that, how can we afford to get in litigation over something to determine what the answer is? And if we do, and the courts decide something that we can't live with, and then what do we got that we paid for? So that's why we take care to do this. It's not so much that we're managing growth through water, just through water, and not all the other aspects of development, a little more out of the picture here. It's like, okay, if water is the issue, then we should be able to address the water issue. If it's growth for the sake of, growth and what people want the county to look for, we need to hit that one in another area, and that's the comp plan. And so we're gonna have to get there sooner or later. And I know that, a lot of what we see today is if the comp plan isn't adequate, we're gonna get it from the water side. And we need to address it in the interim so that we can get back to a growth plan that then addresses the growth rather than the litigation that goes on coming through the water industry. I hope I'm not confusing you. That is a real issue that's been going on for a long time. If you don't like the way growth goes and the way that the county manages growth, then hit it from the water side. We don't have the capacity.
Well, I
Which may be
understand,
true.
I understand that, but I mean, let's go to large lot, subdivisions. I mean, if we're talking about creating, taking 80 acres and creating 420s out of it, we can't do that right now unless we mitigate it. Okay, well, a 20-acre lot is pretty big,
Yeah.
right? So it's
Right, that's true about a 20-acre lot. Now, there's other growth potential out there besides a 20-acre lot. Depending on where you are.
I understand that, but that doesn't have to be that piece. If there's a ton of water there, the water's not the limiting factor.
That's what I'm pointing out here, is that,
Right.
is that if water is the limiting factor, we put an overlay on it because water is concerned, then we need a way out if we can address the water issue. I'm speaking in favor of what you're trying to do here.
Okay.
I'm making a point about it though, and the point is that we want to make sure that if we're dealing with these water issues, that if the focus is the water's growth control, we need to think about the rest of this as well.
I agree with you. No, I totally agree with you. If the transportation grid is not there,
The comprehensive plan isn't there to address all those issues.
If the transportation grid is not there, if the infrastructure is not there to support 1 acre zoning, 5 acre zoning, 20 acre zoning, then it's not there. But if the water is there,
Mhm.
but people say that that is the controlling factor, that's something that, needs to be addressed.
Yeah, so that's what that's just
I know
keeping
you're-
that
I
in
know what you're
perspective, because I tell you, you want to have ecology answer the questions, and they're going to back away from it because of litigation, but they're also going to back away because we don't have a comprehensive plan that addresses our growth issues and tells what we really want. And so what we're going to settle with, because we're in litigation over it, then I can see them backing away from it and saying, we don't want to get into you guys' land use issues if you haven't collectively decided what you're going to do. And so if they get in it and they start getting into some of the details that allow us to do development because of the water, then they're also getting sucked into maybe a case that will establish more water law by the courts. That will be a changing environment for them on a regular basis, and they won't know what they're doing, as we see today. And those are, I think that a lot of those are growth-related issues. Certainly water is a concern because, if you go in and do a lot of development and lean on the senior water rights, and one of the senior water rights being considered in-stream flows, that's an issue, but I think also there's a growth issue that people are concerned about how the county grows. I think. I'm sensing that. And I've sensed that over many years, the issue with growth and how growth occurs, and I'm not anti-growth, and I don't think we have to be, but it's no different than a gravel pit. No gravel, no growth. No water, no growth. No transportation grid, no growth. It's like, okay, so what I think the message I'm trying to say is that if we're gonna have growth, let's manage it properly. And in terms of water, we need to have some fairly rigorous sort of standards. And the one that says we can mitigate that, where we don't know what the mitigation looks like, I'm a little concerned about, and I think others will be, and I think we put ourselves in a position for a lawsuit, so that's why I say, let's prioritize the water. And in a position paper. This right here I just feel it's a little ahead of it, but I also think that there should be a mitigation measure available because there's certain proposals that we don't know what they are. And they may be very simple. And we look at them and we go, okay, great, but I don't want them to be the complicated ones where I tell Perry that I paid $10,000 for it because that's not on the table anyway. We don't. What you pay for the work that you have done is not an issue in terms of mitigation, because Perry is blind to that, right?
No.
Nobody
That's
ever-
not-
$40,000.
That's
Nobody
not-
ever
That's
shares
not where I
that.
was going with that. So let's not take this out of context.
Okay.
Where I was going with that was a 10,000 drum with the holes in it on the napkin. Well, that's what I can afford to do, to show you. But those two things are obviously going to have a lot of different weight, no matter what, in a planning director's mind. That's why it would be nice to have a mitigation plan, okay, where you have to follow, you have to provide us with this information. This is the criteria that we are asking for a mitigation plan.
Yes, and it has to be defined as whether it's in-kind mitigation, out-of-kind mitigation,
Whatever-
and
whatever
a
it
cistern
may
is
be.
about the simplest piece of mitigation I could have, as long as.
That's right. However, our own state health, county health says, well, we don't have a cistern code right now because getting water there in the wintertime can be fairly sketchy. Okay, so if I came in and said, well, I live at the very bottom of Methow Valley there, where I know that the snow level over here is, you don't get a ton of snow. I want to put a cistern in. And, here's where I'm going to get my water and everything else. Well, is that acceptable?
Yeah. To me, it should have an acceptable element to it, except that if it has holes in it, that's aquifer recharge is different. So that's what I'm only getting at, is the fact that if it means aquifer recharge, you're gonna have to have a report, a hydrologist is gonna have to,
Mhm.
listen to that. If it were somebody that actually, if we were talking about mitigation on an existing lot especially, I would be going, yeah, they need an option. Absolutely. If they're going to subdivide their land, I would start to question them a little bit. But then again, there's certain circumstances where people subdivide their land.
Reports, mention that they look and they, what I'm saying is that there are ways
Yeah.
to mitigate for water use.
They have established septic systems. You're staying at, there's a no, I don't have any proof. I had
I
it.
understand that you don't, but you're never gonna have any proof of that. Period.
Okay.
You're never going to have any proof of that.
Okay,
because
well, okay.
The county does not have the resources to go out and perform these studies unless other people are helping us to do these studies.
Well, I agree with you.
Okay, that's why if we have something that's a mitigation plan, and somebody comes in and says, hey, I wanna do this, I want to prove to you that this can be done.
Okay, let's just move on with this then. You would be comfortable with adopting that language today, and you would be
No.
comfortable with implementing it? Okay,
No,
okay,
I already said that.
okay.
But that was the first,
That's
that
what we're
was the
getting at.
first thing that came out of my mouth.
Yeah, I didn't hear anybody resoundingly support anything. But I believe I did make the observation, it's a rough draft.
Mhm.
So, what, as I understand my instructions, I'll go back, I have some ideas for how I can polish this up. What I'm going to do is borrow from other bodies of regulation that we have in terms of language. But I'm also gonna make these phone calls, check with DOE, I'll reach out to some of the Water Conservancy Board folk.
If some of this is going on in eastern Washington, they got it figured out, they haven't been chopping on it, I would love to see.
But we did already.
No, I saw some rather expensive mitigation processes that were going on in different places. And I didn't know the circumstances around them. I saw the methodology being applied on the screen, and some information provided with it. But in the circumstances of X, Y, or Z, small subdivisions or things like that, I didn't quite make the connection. I mean, I'm a little slow on these things.
No, I guess where I look at it is, if you can do it on a grandiose scale, you should be able to do it on a small scale.
That may be true. I wouldn't argue that point. I would say that if they came in with a project that says, I'm going to apply this methodology on this site, it's engineered, it's possible that we could say, yeah, those are the kinds of things that Perry could approve in consultation with the ecology. I'm a little concerned that they might not give you the robust support that you need to make the decision, but maybe. So I'm just
That's a
saying.
mixed bag.
Yeah, I'm just saying, I'm not, what I'm saying really is that I'm not, I see the technology. There's other technology, including water saving. I see that and how it's applied and how it would be proposed and approved. I just want to be a little more certain about that. A lot more certain about that.
Then we better move on because we've got several items that are fairly important that we need to cover at least.
This is,
I have a feel for what I think the commissioner's
Okay.
looking for.
Okay.
Let me make another run at it. You may not see it next week. I do, and that's actually number 4 on your agenda, but I'm gonna see if I can't go into lockdown. I'm close enough to having my draft EIS out. I can actually taste it. I wanna put that last burst, to get across that particular finish line, so you may not see it back next week. Maybe you will, but, don't,
I'm okay with that. And I do understand Commissioner Hoover is concerned about, he's getting calls on these.
Not,
particular-
understood. If I can get it out earlier, I will. I just didn't wanna, I believe they call it expectation management.
Yes, expectation.
I'd rather get chewed out for not bringing it to you after I said I wouldn't bring it to you than to tell you it's gonna be there and not deliver, so. Dan, any observations from your end of this discussion?
No, sir, not at this point.
Okay, I mean, we sometimes forget that Dan too has a permit counter and people come in and express their interests and challenges
Well,
there as
He would
well.
like to see some certainty when he has to answer those questions.
No doubt.
Yeah, definitely.
And I want to have that too. It's,
Actually, as a segue into our next subject, why don't you pull up the resolution?
Are you done with me, sir?
Well, that's kind of up to you.
Oh,
This
all right.
too
Well,
ripples, this too ripples into your world. When last we chatted, and since that time, for that matter, the discussion was, well, let's put it into a document so we can take a look at it. So what I have done, titles, obviously your major players or your comprehensive plan requirements in the planning and as the county's responsibility to determine, there was a long list of things, but if appropriate provisions are made for potable water supplies. And then 1927-097, your building permit codes, which require that there be evidence of adequate water supply before Dan, in this case, approves a building permit. Now, he makes that decision, if you will, in consultation with the planning department in terms of legal and physical water and public health, in terms of the pumps and pipes and the actual quality of the water to the faucet. We have the in-stream flow rules, which now ESSB 6091 has separated into those which explicitly regulate permit exempt wells and those which do not. 49 Okanogan does not, 48 Methow does. And then you have kind of the historical narrative there. 76 they adopted, 173-548 in 91 they amended it to include the closures found in 050 to groundwater and hydraulic continuity. Prior to that, that was not the case. They created the maps in 91 with those amendments. They are reviewing those maps now as we speak. The 2 CFS reserve in each of the 7 reaches for domestic use, single family, domestic use stock watering is senior in priority date to the in-stream flow rule. So that is kind of your broad strokes background. Along comes Watcom-Hurst, which, and it's just a culmination of a litany of cases that has, and some will argue didn't expand, some will, but it does refine, or if you will, put a finer point on the county's responsibility in terms of the use of permit exempt wells. So we have that, along comes ESSB 6091 as we talked about, but we also had late last year the Department of Ecology's change in the application or their interpretation of how they apply the in-stream flow rule in 48. So all of those things have kind of gotten us to where we are today, and we have been evolving in our decision-making processes. When somebody comes into the counter and says, I have this, and I want to do this. So what we've done, go ahead and roll to the next page on this thing, the attachment if you will. I just went through and wrote down what we're doing. Hubbard here can point out if I've forgotten any of the scenarios that pop up. So someone comes into our counter, I have a well, it was drilled in 1970. I want to put another house on it. We apply 90-44050, permit exempt well statute. It's not regulated by 173-548. We go from there. you have a well drilled after 76, it's subject to the in-stream flow rule. So has it been put to beneficial use? Is it in the restricted area of the closed basin? If it was it drilled before 91? If it was, you're not going to have the letter from the Department of Ecology saying you can drill it and it was drilled correctly, because they weren't regulating groundwater in the closed basins prior to 91. So we have to make that further subdivide. So it's a post 76 well, drilled before 91. We look, is it in the restricted area, is it not? Has it been used, has it not? We apply those questions to our determination. If it's after 91, we require that they have the letters from the Department of Ecology. The first one authorizing drilling the well, the second one saying you drilled it right, if it's in the restricted area. If in the end of all that, we determine you can use the well, we charge it against the 2 CFS reserve, so you're okay for domestic use and stock watering. If it's commercial, we never run across an irrigation well, but it would follow with that as well. If it's commercial use, irrigation, subject to interruption. Now, we went through that discussion with the Department of Ecology, whether that is their decision to make under the banner of other water available for further appropriation versus not. It has come back to us. So, where am I? Existing wells, as we talked about this, after 76 but before 91. Go ahead and roll on through, keep going, keep going, keep going, keep going. Okay, group system. Now, part of this is in red. This we're not doing right now. So this is new discussion. So let me make that distinction. If it's an existing group system and it went through an approval process, now we generally find two. One where it was specifically in the subdivision proposal, be it short or long plat, PD, whichever, where they actually proposed to use shared wells or a group system. Went through the public process, that was subsequently approved. Or it was those systems which the Department of Ecology approved for the most part in that early 90 time period, and for the most part with mitigation. So somebody wanted to put a group system in, they had an irrigation right or something along those lines, they would give up part of they didn't convert it. This was a little different than what they would ordinarily do now. They didn't actually convert it to domestic use, they just gave up part of it.
It was mitigation measure.
So it was mitigation, but they still considered it a permit exempt well, and they still considered it as charged against the 2 CFS reserve. So those existing group systems were honoring that decision. New group systems, again, let's come back to that. Go down to your existing lots. Existing lot, no well. You're outside of the restricted area, barring some other challenge, adjudication, or something of that nature, they can go ahead and drill the well. Inside of the restricted areas, they can't get a new well at this point. We don't have any approved mitigation measures. We're talking about it, but what we tell them now, you don't have a well, you can't get a well. Then now your subdivisions, we're allowing the, back to the existing lot inside the restricted areas, you can't get a well, so you have no water supply. Now, the Department of Ecology said you can drill outside and pump it in. We haven't really put a fine point on that yet. If you're propose a subdivision outside of the restricted areas, each parcel has to have its own hole, is what we're doing right now. You can do a well field, they can all be on a neighboring parcel, where you got 4.
Up.
Okay, go up to that. If we want to depart from that, and we've had this discussion a number of times, the Department of Ecology has respectfully declined to weigh in with any legal interpretation. Some would suggest that having a whole bunch of holes in the ground isn't the best for the environment. If you have a group system, it opens the door at least to more effective metering. I know the commissioners have talked about metering. You can meter both at the wellhead, meter at your point of use. There are some advantages to a group system rather than one hole per parcel. It would still be subject to the same restrictions in 9044-050 as interpreted by Campbell Gwen. When we have a subdivision, 4-lot short plat, even if you want one hole or are required to do one hole per parcel, you still only have your 5,000 gallons a day to work with. Or if you poked one hole to provide water to the 4 lots, you still only have 5,000 gallons a day to work with. Now, depending upon the proximity and time, you may have less than that, because we have in past had short plats, for instance, where we divvied up the 5,000 gallons a day, and now somebody within that short plat wants to make another lot. They are only allowed to divide the quarter of the 5,000 gallons a day that they had before. I can't give you a bright line for how far back we go. Usually we go back to the period of time where we were putting water allocation tables on the face of the plats. But we do apply that standard. Again, this we're not currently doing, and this is after our consultation in times past with the Department of Ecology, where at that point, they were more comfortable with an individual hole, separate hole for every parcel. They have since chosen not to speak to that.
Is, so the group domestic, the Campbell Gwen decision, is that in debate?
I did that, what, I'm sorry?
Debate over the interpretation of Campbell Gwen today?
Oh, no, there's debate.
I mean, is there debate to the point where it's been to court recently?
2009, 10, 11, that, and then where it generally worked out was if you had a plat, you did 5 lots. Under your Campbell Gwen limitation, each one only got 5,000 gallons a day. In 15 years, each of those lots would perfect now a new right to that withdrawal. I haven't seen that really pinpointed in case law or in legal papers. It was just kind of a discussion that people had. The other challenge you have, the debate, if you will, is when you're doing large lot, say of 5817. Now, the rulings would certainly imply the courts don't necessarily agree with that, but they've never said that. They've never said 5817-110 and 3670-330 and all of these things trump 5817-040. I read an implication in that, but it isn't said. I haven't found anywhere where it says that. So you have that whole discussion where your exempt segs and your large lot subdivisions. We've had some pushback, and you'll recall we were actually requiring them during the old Title 20 days to demonstrate water availability. We got a lot of pushback on that, and they always cited 5817-040. The other debate is more from the viewpoint of a fundamental fairness. If you have somebody with 2,000 acres, they get to divvy up one 5,000 gallon a day withdrawal. If you have somebody with 10 acres, they get to divvy up one 5,000 gallon a day withdrawal. And some see that as fundamentally unfair. Again, the Campbell Gwen interpretation would be, well, yeah, tough. That's the way we've applied the rule. But you'll recall in past, the Department of Ecology has actually applied other standards. Silver Spurs, back when I first got here, as a matter of fact, they were applying a 1 in 20 standard. So every 20 acre parcel got a withdrawal. That morphed into 1 in 40. They finally backed away from that. And when we went through the second phases of the Silver Spurs, we restricted them to 1 11 connection Group B system, and for the rest of it, they had to go get a water right. So a lot of debate and ongoing around that question.
So a question back up the line of decisions, the early pre-76 wells. What do you use for the evidence of those wells?
I'm sorry, again?
Well logged.
What do you use for the, you just use?
Well, how do we determine this?
On the 76.
Well logs is what we hope to get.
So if you don't get a well log,
If we don't get a well log, we'll try to establish that there was something there to use the water. So aerial photography, we can go back into the early
whatever
stuff.
you can.
Whatever we can find. We rely on the applicant, the landowner, to provide to us if they have something.
Yes.
So it's kind of a totality of the evidence, if you will. And then the ones prior to 76, we don't always have a well log. And we usually are able to go back into assessor's records or aerials and show that at least there was a structure there. Implication being they were using something as a potable water supply.
Yeah.
And sometimes we can't. Those cases where we can't, we can't,
I'm sure
and
there's plenty of wells that are just dug back, tile surface ground, that's the well.
now, of course, E ESSB 6091 talks about wells constructed in accordance with, I think it's 18104. Now, the earlier wells with the well log, generally we're able to determine that, or at least we have no reason to disbelieve it, maybe is a better way to say it. Some of the earlier ones, that isn't necessarily the case. Matrix that we employ, see if there's any challenges from your perspective with any of it.
Well, the thing that I see is that we're charged with the quantity and quality of water. Kim Gwynn was a land use decision, group system. Department of Health is regulated under public water supply. So Group B system is a public water supply. So if we allowed for group systems, they would be regulated under the Department of Health, which would mean that we would have more information on the quality of water that's coming out. So I see conflict between the WAC and single domestic use and trying to make sure that the quality of water is also maintained. Because more holes means more potential for contamination, and if you're serving enough people from a Group B system, you have to test your water. So those people will know what's in the water, we'll know what's going on in the water system. Whereas on a single family domestic withdrawal, you don't have any responsibilities to test your water.
Well, in my opinion, strictly my opinion, none of the terms necessarily straight across interchange. Go up to the very top of the resolution. So 330, comprehensive plan required elements. The land use element shall also provide for protection of the quality and quantity of groundwater used for public water supply.
Oh, so
Yeah.
does that mean over in 48 that we do not have to regulate that? Because
Well,
none
see,
of it
that,
can be a public water supply?
which is my point. They didn't mean city systems here. They meant water that the general public would use for potable water supply.
But if we want to read this as the letter of the law,
Fair, I understood you, and the point I make is you can't necessarily, and this is true of many codes, you can't necessarily pick up this phrase used here and walk it over and stuff it somewhere else and have it necessarily make sense. They're written in a compartmentalized basis, they're written out of context, so. Moral of the story though, the comprehensive plan required elements, I believe we're getting to protecting the groundwater that is being used for potable water supplies for the people in the state of Washington. And we're trying to do that. In terms of Campbell Gwen, the thrust of that, and there were a number of arguments made by the landowner in Yakima County. One hole or 50, you still only get one 5,000 gallon day withdrawal. So they didn't try to define what was a group system or public water supply or anything else. If it was a permit exempt well, which is a permitting threshold, you only got one withdrawal, not one well, one withdrawal. So there, you know, the whole group system was in a little different dynamic than what they were talking about. The collective subdivision application only got one withdrawal. They didn't go in to just find Class A, Group B, or any other type of system. They didn't care. You got one withdrawal, so. The objective in this, commissioners, is as we continue our discussion to create, and we already have by necessity, but I guess maybe a better word is to codify our local policies regarding permit exempt wells. Now, 48, as we talked about just a short time ago, is in a different world because of the structure of the rule and the fact that we're not updating it. It says what it says. So where it appears that Department of Ecology is of the position that it's up to us to administer the rule, at least in terms of local land use decisions, we need to get our policies polished up. Section, permit exempt wells or some such thing. Keeping in mind, we do have 6 WRIAs that come into the county, little tiny piece of 47, and then fairly significant portions of others, somewhere how we deal with permit exempt wells in those different geographic boundaries probably has some benefit. Observations.
You brought that up a few times, those different rides, and I would, just to get that off the table.
Well, the sand poil comes down into that system, doesn't it?
Yeah, yeah,
That's one of the rise.
Right.
And the kettle crosses.
yeah.
Say Kettle Falls.
Have you had any discussion with the governing bodies in those riots?
What we were doing in the Title 20 days, when we had water availability applications, and that portion of it in Okanogan County, we would include the folks on the other side of the line in that note, including the county government, in that notification process. So they knew what we were doing. We never received any feedback, but we knew what they were doing. But that's what we were doing in those days. Now that portion of 20 has come off the books. It's not, there's really little mention of them in 6091 other than eventually they'll all get in-stream flow rules. We really haven't done any outreach in terms of the other planning departments.
You mentioned
Now,
this
it's 50, isn't it, on the
50
reservation?
and 52.
Okay. What we do there is all, and then we stand by that decision.
And they've ruled in favor of the fee landholders in the reservation?
So far, yes, I don't recall them
I don't recall.
turning down any. We haven't had a lot,
Right.
but we have had some. And they always review it, and I believe so far they've approved everyone. Further the work?
Yeah, I think that you're defining some policies and how we deal with things today. We talked about position type paper. Is this what you intended to represent?
I made it a resolution just so I could throw some recitals in as well. If you go to the attached, it's a position paper.
Okay, because if there are issues that are holding us up or we're having differences in opinions with those approving or not well applications, that was what the purpose of that was. If there's controversy over the issue, that we'd want to put that down on a position paper so we'd
Go
have a
back to the
discussion
red
with
line.
ecology and health on it. And
The one scenario that we generally get high centered on more than anything else is the new group system. Yeah, folks with, and there's different scenarios, yeah. And some, while we had that discussion there for a period of time, at least public health was was approving those two connection systems. We were not, because it didn't pass muster in terms of the existing group system. So we've had challenges with that. We've had folks that want to do subdivisions. Generally, they're 1 or 2 lot short plats, although not always. We have the one that's ongoing now that we're still wrestling with, where they want to create 2 lots and share a well. We don't allow that. They're required to put a separate well in for each parcel. And they don't want to do that because of generally it's in an area where you're drilling some pretty deep wells. You may have enough water to want to do, but they don't want to drill another 250-foot well.
So there's the comments that you're receiving on short plats that are opposing the approval of those short plats as a result of shared wells?
It's an interpretation of what constitutes, actually, if you get to the final analysis, what constitutes a public water supply. When you read the in-stream flow rule 173.548, you have essentially 3 categories of water. You have the 2 CFS reserve set aside for single-use domestic and stock watering. You have the in-stream flow appropriation, and then you have other water uses, which is irrigation, public water supply, those sorts. The argument is that the act of subdividing land is a group system, and I assume that borrows from Campbell Gwynn. The group system, if you go to the public health codes, anything more than 1, except for a farm, which was an interesting exception, but if you got more than 1 connection, it's a group system public water supply. So as a public water supply, it's not eligible for the 2 CFS reserve, therefore it's interruptible, therefore you can't put domestic use on it. Is the cut and thrust, as I understand it, cut and thrust of the argument. Our disagreement is that simply because you have a shared well does not a public water supply make. So that's really it isn't so much group system, it's public water supply where the debate lies. Again, my opinion. So this is new. We're not currently doing what's in the red.
You have somebody in the audience trying to get your attention?
Yes.
Commissioner Branch asked a question that is pretty clearly answered in letters from the Methow Valley Citizens Council on applications to use a single domestic well for subdivisions. And I believe that the commissioners have received copies of those letters. The latest one is on the near subdivision proposal at the Meadows Road near Carlton, Washington, and the application was in April. Our comment was May 22nd, 2019, and the comment is that it's exactly what Director Huston said. Our contention is that the law does not allow a single-use permit exempt well to be used for lots, and that the county is continuing to do that, and the county had okayed it with this near single-use exempt well as a water source that would then be counted in the 2 CFS reserve. And there are comment letters, that one and others, saying that our interpretation is that the county may not do that.
So that's what I'm trying to get at is, I saw those comments, of course, and that's an administrative process that Terry deals with. And if there's conflict in interpretation, I just want to know about it. Do you understand it?
Me? I absolutely understand it. And I can read the definition of single-family domestic and public water supply out of the basin plan.
Okay.
which was not included in the rule. So I'm on it right now, I can absolutely read from it right now.
Could you get a hold of Dick? He asked a question at that meeting that I was at on Friday about this. And he's now the acting farm director.
Gary, a question for you. Do you feel uncomfortable, inappropriate, or inappropriate about the discussion about this being in a discussion about a decision you're making?
What's the discussion? I mean, at this point, as I understand the position of the commissioners, was one hole per parcel.
So,
The Department of Ecology in past discussion was comfortable with the one hole per lot approach.
Mhm.
They weren't comfortable with what would be the language in the red. But that said, I posed that question again, and they elected to not offer a legal.
lawn or garden irrigation. It is the 1976 definition of single domestic use. Water used by a single household. It has nothing to do with the way that that water gets there or anything like that. Now, however, if you go down to public water supply, which is the third one down in mine, the system for collection, treatment, storage, and distribution of potable water from the sources of supply to any community, collection, or number of individuals, excluding water supplies serving one single family dwelling. This has to do with talking about that if you have a system that collects and distributes water,
To your question, Commissioner, I'm approving them, so I've supported the one hole per parcel approach. Because that, traditionally, we've never regulated that as a group system, other than in terms of your physical and functional relationship under Campbell Gwynn. We'd have to do some additional discussion on this to see if we are comfortable enough with the information the commissioners gleaned in terms of the intent of the in-stream flow rule to approve this sort of an approach. I mean, you can make all sorts of points about environmental improvements, overriding public interest, metering water, all of those sorts of things, but the court, at least in other circumstances, kind of dashed that to the ground. No, follow the rules. So the definitions that the commissioners talked about, we should probably all put in one place and take a good look at it and see.
Yeah, and actually, it may be well worth the effort to have conversations, discussions about all of our interpretations together to try to figure out why we might think one way or the other, rather than having attorneys do it in the courtroom.
I assume part of the discussion would include, how much water is left in each of those two CFS reserves. The lower Methow we've already recognized. There may be some challenges. You've taken the step of amending your zone map to remove the bulk of the 1 acre zoning from that area. So birds of the same flock. The question of whether, and then to me that's really more the point, is there water left in the reserve? If there's water left in the reserve, and that's your potable water supply for your subdivision, that's what the water's there for. If there's not, that's another discussion, rather than the debate, how many holes constitutes a group system versus no or whatever. more is there water left in the rule. We are ordered now to follow the rule, and according to DOE, that's our responsibility when it comes to land use decisions,
And
so.
what it means to different people, I guess the group system part of things is that obviously, from the health side, they're discouraging group systems just because of the challenges in managing these systems. That's just,
No, from the health side,
like, pardon the health side,
but they're not discouraging
group systems.
group systems.
Oh.
That's not what I heard.
Well, they were approving them. We were the ones that were not allowing the groups, the new group
Maybe
systems
group B systems.
after our consultation with
Because,
Department of
Group
Health.
B systems were not, they were not being regulated. The state stopped regulating them. However, the county, Department of Health, has a regulation, has now regulation authority over Group B systems.
So the entity now, since what date is it, that they put regulating the group systems?
I'm not sure when we got when we started, the
I
new
remember
program.
that, I remember the legislative fight, Wes McCarp led the charge on that, I think it was 2 years ago.
Okay, relatively recently that they've relaxed. And then the regulation before was your workbooks and those sorts of reports
Yes.
that they had to do more regularly.
Yeah.
Of course, Class A is an entirely different.
Yes.
So that'd be before the break, as I recall, maybe you remember, Angie,
Yeah, I
that
might be stuck.
if you had a two-well connection, they didn't worry too much about
Yeah.
that. But if you went beyond that, up to your Class A, which was 14 or 11, the state public health interpretation of the second half of that
So that's not really
definition.
a relevant issue in this conversation.
I mean, that's how public health was dealing with it. If we, my, just thinking out loud, if you will, if we were to return to, and I'm talking the legal use of the water and allowing group systems, I think it should be accompanied by probably some specific requirements in terms of metering and those sorts of things.
Quantity related issue.
Quantity related, how much are you actually using and then how much is each point using, so that they can actually regulate that. I mean, we have required meters in past through the plating process. I don't believe any of them actually went to final. At least none come immediately to my mind, but we're required. So that's not completely new ground. And of course, the bigger systems meter anyway. So.
Because in the group systems now, so that the responsibility or the concern, maybe not responsibility, maybe it's just concern, is now delegated to our health department. And so I was just curious, well, we can have a conversation about that and learn more about that later, but, you know, one of the problems with the group systems was, and maybe that's why they don't regulate them anymore, because then they were having a heck of a time dealing with it. And that is that they were loading up on nitrates and things like that, and they couldn't meet water quality standards. And so they were on boil advisories and things like that. So I guess if we're responsible for it or not, we need to know that. If
I guess, and maybe public health would disagree with me, but I guess I was still making that break between approving the legal availability of water for a
Yes.
group system versus the pumps and pipes.
Yeah.
They still, we don't do that.
It's public health, fundamental public health thing, yeah.
I mean, obviously, public health needs to eventually be brought into this discussion.
Yeah, I just, because if it was a concern before, they were actually doing water, oil advisories and actually paying for them, they're paying for them to hook to municipal systems today, then it's just, we don't want that part to slip by us in subdivision.
Yeah, understood. And you know, this is a very, very, very general
Yes.
sort of statement. Obviously, if we're talking about approving 11 hookups on a well, that's a different discussion than two lots side by side sharing a well.
Yeah.
So there's
And do we draw a line?
lots of different things involved in this discussion, but I did put it in because we had the discussion the other day.
Mhm. Thank you.
So, I will go through and polish this up a bit more, make sure that it's very clear in terms of what we're currently doing. But let me now apply what I lovingly call the what test. What would the commissioners like to do with this? I can bring it back for you to consider for adoption as your actual policy. I can codify it and bring it back in an ordinance. We can bump it up and send to the planning commission for their review and discussion. I mean, we're doing it now, so we're not talking about nothing being decided until we finish this. This is more of a, this is what we do, and a refinement of that, perhaps an expansion of that, if the red language you find yourself.
I have a question, and it goes for everybody here, and that is there a conversation that can take place that talks, where we can have a conversation about what the primary concern is and the short plats and how they're being applied to exempt lots? In other words, if I see a consistent challenge, whether we believe it's right, wrong, indifferent, legal, not legal, our interpretations of things, I would like to know if we could hone in on that particular issue, just to see why it's an issue and how we might address the issue. And that would be probably a message out to the Citizens Council. It's like, is there something here that may be resolvable in terms of interpretation?
We can certainly open the door to that discussion. I would suggest we keep it general. I would be hard pressed to sit down and talk about a very specific application in front of me
About the application.
because of the quasi judicial
Absolutely.
stuff that we have to deal with. But in terms of broad policies, hey, what do you think? What's going on?
Yeah, no, absolutely, because what I'm saying here is if you're getting the same letter for many applications or fees, then it obviously raises a flag that says, wonder if we ought to take a look at this and see if it has merit, if it could be resolved and why it's an issue.
Who's gonna look at that and decide that?
That's conversation, so I suggest a conversation about it.
Okay, well, the conversation goes that under Campbell Gwynn,
Oh, no, okay. No, I understand what you're saying. That's the interpretation. I hear somebody else saying they have a different interpretation.
I know, so I'm gonna ask you, who's going to make that determination?
Well, when it comes to just my own personal view of the challenge, me. Because honestly, that's all I'm trying to figure out, is that if you're going to have a legal argument, maybe we have one in front of me and I can be the judge, I don't know. It's still, it's going to, if somebody asserts that this is what the law says, somebody else says this is what it says, then there's either we locally think about that and decide, how we address that, and it might be, well, Henry's right, that's the interpretation of the law, and that's the way we're going to do it. But when I see a consistent challenge, if somebody comes in and they consistently don't like something, even when there's no law at all, you pay attention, right?
I do.
Yeah.
But when it's consistently by the same group,
Yes.
okay? When
Okay.
it's consistently by the same group,
Yeah.
and that is a form of basically saying, okay, we don't want. Let me read from this. Let me read from this really quick.
Okay.
Because you made an interesting statement about, well, we need to figure out what's going on.
No, I
This
need
is
to
the
figure it out, I think.
introduction. This is the introduction to the 1976 Basin Plan.
Okay.
The policies recommended relate to the Methow Basin's hydrologic condition with the current level of development and provide for future development with appropriate protections of in-stream needs.
Okay.
Okay, so that's what it says. So development was contemplated. in the very first paragraph of the basin report.
I agree.
Okay, so, and do we agree that in the basin plan, there's some definitions in the glossary?
I guess my question more is, are there people that say they don't want any development at all, and that's why that argument's being made, or is there something to it? Do you have the answer to that question?
I could only speculate on that.
Well, I'm speculating here too. That's why I asked the question. So if I see something that's being brought up, I have this propensity to ask why.
Okay, but who is going to make the decision? That's what I want to know. Are we going to sit here and make the decision that tells the planning director that go forth and keep doing what we're doing? Or are we going to keep doing that, or are we going to listen to someone else who speculates on what we need to do?
I guess on that note, I'll just think about it.
Okay.
So what avenue do we want to, or instructions do we want to give here?
Well,
I would like to know what RCWs, not wax, what RCWs look like they would be in conflict with punching multiple holes in the ground. So I know that the Department of Health has statutes and WACs that they have to follow to provide for the quality of water in the public water supply, which we have to, under our Planning and Enabling Act, have to look at also. So I think having all of those pieces put together would help to frame this red portion right here. The other black portions, if you're doing that, I don't know that we need to codify that right now or do anything you want to send to the planning commission. Yeah, we could send that to just as a document. Here's what we're doing to the planning commission to get their insight on it. Correct.
I think that anything should go by the planning commission.
You think that?
I think anything that we propose should go by the planning commission.
Okay, I agree.
I will do some research, I'll pull up the RCWs. I've actually done some of that in the past, so it shouldn't take long if you pull that off. I will package this up with a memo explaining to the planning commission what we're working on. I'll couch it in terms of whether we do it or not, obviously for discussion, but I'll couch it in terms of a code section, something that we could actually put in the book. So if somebody who wants to know can pop open the book and look and see. And, but obviously the planning commission isn't gonna pick this up for a bit. But I think, well, I'll report back out the results of the research and whatever other refinement we might see and do on this thing as we look at that. Crew hasn't looked at it yet, so they might correct to me as they do from time to time, so. That work for the interim? Okay. Commissioners, before we get to the other parts of your planning department study session, let's move to a couple of the things on your administrative study session. The first, under the banner of Tonasket EMS, I would ask you to convene as the Tonasket EMS governing body.
I would move to adjourn as the Okanogan Board of County Commissioners and reconvene as the Tonasket EMS District.
Second motion.
Motion second, all in favor?
Aye.
As we chatted about a few weeks back, Commissioners, the state auditor wants to continue their audit, which was initiated back in 2015, you'll recall. That was a less than glowing one, and they want to follow up to see what sort of remedial actions have taken place. Now, obviously, the remedial action that was taking place was to essentially eliminate the previous model, and now we've delivered services under contract. So I don't anticipate a lot of work with that, to go back and look at the contract, see if the contract is doing what the contract's supposed to do. There may be some things we'll tidy up in terms of some property that's probably still up at the station that ought to be surplused and eliminated, but it's still up at the station, so. And then there's some missing items that I think are still, well, we apparently found another radio. So, a few things have come up and are a little different. But what they do want is us to authorize the audit. They project approximately $8,500 is the cost. So this document is that form. It calls for the signature of the chairman and myself as the de facto executive officer for the Tonasket EMS district. And I apologize.
No, he's just letting me look at it, I guess.
I apologize, Madam Clerk Board, they only brought me one copy,
Of course,
so.
we all get to look at it, right?
we'll-
Yeah, no, I just couldn't remember.
No, I'm not. You're missing. Not my district.
So, and we're paying for this out of
The EMS
the
district.
EMS
would pay
district
for it,
funding, right?
Right, there's no county money per se involved.
Right, so I would move to authorize the chair to sign the letter. What? And. Oh, sorry. And the director, Terry Huston, to sign the letter from the Office of the Washington State Auditor to the Tonasket Emergency Medical Services District regarding the audit.
Okay, motion second, discussion. Hearing none. All in favor? Aye. Aye.
I second the motion.
Motion second, all in favor?
Right?
Aye.
Whatever you'd like. Still on your administrative agenda, Commissioners, you directed us to move ahead with the public hearing for the purchase and sale agreements, what I'm talking about now, the Miller property, for the potential gravel pit site. In that discussion or subsequent discussion, you suggested an open house be scheduled, which we did. So your public hearing is scheduled July 8th, 1:30 here. That's a Monday. Your open house was scheduled June 24 at 1:30 here. That's a Monday. Some folks have called and have suggested that it would be very convenient if we could have some kind of an open house there in the town of Methow. Commissioner Hover's district, I chatted with him. He had no objection to it. It doesn't necessarily need to be a full meeting of the board. Mostly what they were looking for was just some additional information, opportunity to ask questions. So what I was thinking, Commissioner Hover's the district commissioner, myself, who's kind of shepherding the process, and Mr. George, the road maintenance supervisor, were to set that up. I think that would satisfy what the folks were asking for. We were thinking of the week of the 24th. Certainly nothing to say that the commissioners couldn't attend. If you wish to, we'd have to, the clerk of the board would have to notice it as a special meeting and that sort of thing. But I haven't got feedback yet in terms of the availability of either the community hall or the church. So we're looking at the, let's see, it was the 25th or 6th.
Wednesday, because Thursday, Friday, I have the.
In the evening was what we had in mind.
I suppose Monday would be fine too, in the evening.
So, do you want the full board to be there, or?
I want, it's not a matter of want, if you two want to come, I absolutely would, that would be great.
Planning commission.
So that you can hear, want to hear what things are
It
saying.
would be my question to the group that were asking the meeting whether they wanted full representation from the board of commissioners.
I think that, and I've talked to a couple now, folks who have made voice the same concern. I think mostly they just didn't want to drive here to find out what was going on. So they were more interested in, exactly where's the land. They have a pretty good idea of that, but where would the gravel operation go? What would happen with the rest of the property? When, how, what is the operation plan? Most of what they wanted to know are actually questions that Mr. George would be in the position to answer. I mean, I can explain the process and the upcoming meetings and whatnot. I'm not suggesting that we do that in lieu of any of the stuff we've already scheduled. We've already scheduled it, some notice has already gone out. So I would suggest we still have the open house here on the 24th. We still have the public meeting on the 8th. This would be in addition to that. So I don't think the callers, I don't think expected a full-blown commissioners meeting.
Okay, 'cause we got an email too,
Oh, okay, all right.
and I don't know if the
That
caller
was from-
was the same as the person
That was from Henning, Hal.
Well, I got a phone call from him too. so-
Right,
Yeah, we got an email from him.
Yeah, Chris
you got
was
the
saying,
same-
we got the email, he was making sure that email that we got was addressed.
Oh, okay,
Yeah,
yeah.
I think that you had talked to him about it.
I talked to him and then I had one other email. That name escapes me now.
Yeah, my only question is that if that serves the needs of the folks that were reaching out to us, asking us to have the meeting there, and if that serves their needs, that's fine. It's a reason for us to have a forum there.
No, I-
It's a- Because
You
the,
don't need to have the clerk of the board drive all the way over there and take minutes
there's additional effort,
But
obviously.
we discussed this a little bit this morning, and we agreed that we should do that and do it at the town of Methow, because, when we were doing the Lake District stuff, we went to Oregon.
That we did, no, it's not without precedent at all.
Yeah,
We just didn't think about it at the time.
and then the only other thoughts I have about it is that, as a planning issue, I guess, and it does cost money, I know, that if there's a way to do any kind of assimilation, computer simulation type things, that could be helpful in looking at whether or not there's a way to achieve some visual.
We have maps on the website, and we have the actual purchase and sale agreement there as well. What I'm going to have Gary do is create a map, or we can do it for him if he needs some help with it, that actually depicts in more detail where the footprint.
I also asked them to, they were gonna do some drone flying today. So I asked them to go across the valley and then fly up and take, pictures of different elevations along there to see kind of the, what it looks like. You're talking about artist's rendering, I think.
I'm absolutely, well, it's sort of like that, but more, there's, you do a rendering, but it's a simulation, a computer simulation of your operation as it occurs. So,
I don't know if you have, who has those programs?
well, I just, that's the question that I'm putting out, is to see if there's a way to do that, because it's done. When they did it,
that'd be a question for Ted, I would say.
You know, we
And he's
could
done-
probably.
He's actually done
As
something.
he's done things like that. Not gravel pits necessarily, but he's done things
Well,
like
you know, you
that.
just take, and I think, I draw a parallel to the landfill. And the landfill required something that you couldn't see then because it's been a long time. You may not see that impact, but you have to kind of simulate it. You have to go 1 year into it. For instance, we talked about that earlier about
It's gonna sit on the top of the ground for a while.
When is when is the activity gonna take place? And then if it does take place, what will be there after the first, let's say we did, well, what were you using as an example of how much gravel was created in the initial crushing? And so you've got
We
pile.
crushed, at the Gavin pit with, plans of that rock source lasting for 5 years, and it out exceeded the 5-year window.
Right.
So, one crush.
And in that particular case, there wasn't as much concern, but, you know, if there's a way that operation, that excavation takes place, that it may have a less visual impact, it may be helpful to, this is the way we intend to do that, especially when you go to a conditional use permit stage and people are coming in and saying, this is gonna be a terrible looking thing, and you can prove otherwise by some.
I think, that they can only expose 3 acres at a time without reclamation by state law.
We have to get,
Well, you'd have to have your reclamation plan,
Yeah.
whatever the reclamation plan calls for is what they do. It's me, 30 trucks a day. So I know and I'll talk to Gary about this in more detail. The operation plan is going to be a very important piece of this discussion. You know, how often will, assuming it even goes through, how often will the county be in there? You know, how much material will be moved at any given time? How much material will be stockpiled? How will it be stockpiled? I mean, there's a difference, obviously, between 3 piles, 89 feet tall, versus 1 pile, 15 feet tall. You know, there's a lot of different things like that, that I've tried to work my way through, and I don't have that level of detail. So I'm gonna work with Gary to get that level of detail we can put up, so people know what's going on. That seems to be the bulk of the question.
it's funny, cause I drive by our pit every day to take my kid, or Twin Lakes pit, to take my kid to school every single day. And the amount of trucks that come in and out of there they're barely ever in there. It's not a constant in and out.
The pit up here by the landfill, the pit's actually on land owned by the Wildlife Council. So it's a rifle range the rest of the time. I've been here 12 years now. They've done 2 crushes during that time. But you have big piles. You have big piles because you don't have a big footprint to spread them out on. So if you have a bigger footprint, you reduce the height of the piles.
Yeah.
We talked about, allowing public access up to the, the national forest
Right.
up above that. So,
Another part of the questions and phone calls I've received, obviously they're going across that land with the indulgence of the current landowner, which obviously could change with the new landowner, but they had some concern about if the county owned it, would we be allowed to do that still? And of course, part of the discussion, I built into the purchase and sale agreement, the option for you to enter into other agreements with third parties. Obviously, that was targeted towards a discussion that Fish and Wildlife might well be interested in picking up the residual of that land. So that was about. So anyway, back to pointy beginning. I'll go ahead and see if I can. Monday won't work as planning commission meeting, and unless I don't need to be there. If I don't need to be there, then Monday would work as well. But we have the planning
Tuesday or
commission.
Wednesday is fine.
Pardon?
Tuesday or Wednesday, if that works, would be.
I'll see if I can't set it up for Tuesday or Wednesday evening.
And then if that doesn't work,
Well, we'll have
we
to-
should be able to.
I'm guessing that we can probably pull it off.
Was for the study session to be in Methow
Mhm.
with the full board
Not full board.
At the town of Methow.
at the town.
And it was just Commissioner Holt.
Yep.
So
We're
we'll
gonna
have,
have the study session over here on the 8th.
the 24th
Sorry,
is your
24th.
study session. July 8th is the actual public
July 8th
hearing.
is the public
But now we'll set up an additional open house, question and answer.
Yeah, and if, I'm sure if there's any objection to it, just not happening, the board will get another.
Generally, that feedback comes fairly quickly, yes, so. And I'll just reach back out when I get a date. I'll give a call to the people that have called me
Okay.
and make sure that I'm hearing what they want.
Yeah. I'll ask around if there's a means simulation thing, because sometimes it's helpful.
If we get, we've already I pulled the second mailer that was talking about the open house on the 24th. If I can get the time and place in time, we'll morph that and send another postcard out advertising. It'll be tight, but it's the best we can do, so.
Great.
Then the mailer on the public hearing has already gone out, which is actually what's generating most of the phone calls. People already have that, so.
Hey, is there any indication that there's an impression that that's where the buck stops? Not recognizing that there's actually.
There's a little bit of that, the idea that the hearing is on the gravel pit. And, but once I've explained it, they walked away with that understanding that the 8th is just to decide whether to move ahead with the discussion or no. So,
It could be helpful to us to actually identify the type of, the operation itself, to make sure it doesn't go our way if we do the conditional use.
I mean, keeping in mind that the 8th is to decide whether to move ahead with the feasibility period. The feasibility period will also mark the application for the conditional use permit for the gravel pit, which you have to obtain like anyone else does. But the information gathered from your public hearing might well, and I would suggest will, prove to be useful when Public Works puts together their application, because the application would include operating hours, it would include conditions in terms of stockpiling, footprint, those sorts of things. So it should be a useful endeavor. Because one of the things we often encounter is applications that could be better refined. So
Actually, what we're gonna end up needing, and that's, of course, at our hearing, is the same sort of information in regard to what does it look like, as a part of our decision.
M-Tank ceiling project, I sent an email to Beeman's Architecture telling them that the contract had been signed. I assume that in your distribution, they'd get their copy.
I believe so.
Yeah, okay, so.
That was the plan that I set in motion. I haven't checked on that precisely,
Okay,
but
I mean, that was my assumption, so I didn't, so I assumed they were getting it. They didn't tell me they didn't, and anyway, I'll see if they, well,
they are supposed to.
I didn't, and I should have. Remember the last time they sent us the forms that had their old contact information, we had a bit of a,
I didn't check.
well, no, nor did I. I'll check and see if they got it, just to make sure, courtesy.
Yeah. Let me check.
But anyway, they're beginning work on that. So the next step, the design, put the bid together, that will come back to us to take a quick look at. Then they'll actually put them out for the call for bid. Let's see. Let's go back to your planning agenda. Comp plan, the terms of upstanding, what the current after that for the public comment period. I'm going to do a 45-day comment period. I recognize that's more time, but I think it appropriate that we have enough of a comment period that people can offer their observations. I do want the July Planning Commission hearing to be a public hearing on the comprehensive plan and the draft EIS. And that'll be about midpoint or so of the comment period, so if people have an opportunity to follow up. Planning Commission always has the option of continuing the public hearing. So I want to make sure everyone has a chance to explain their concerns, what they want changed, what additional analysis they want, all the sorts of things that inform the final draft of the final EIS and the final comprehensive plan from the perspective of the Planning Commission. That all then comes to you for your review. So Lord willing, and the creeks don't rise, I think we're still on track to have a new comprehensive plan in place by the end of the year. 49, water plant update. The aspect agreement I'll bring back over for you when I verify those dates. The initiating governments meet this Thursday as kind of an update. They'll discuss the process or progress. We have the recommendation from the planning unit that we pursue the additional money for the model, the computer model, which will be used to assist in the evaluation of net environmental benefit, net ecological benefit, and to let out an RFQ for a basin by basin assessment. That is something we, the lead entity, would have to submit. So I've been in contact with Vanessa Brinkhouse. I have the notes from all of those discussions. It appears I'll be making the first run at the application for that additional money. I'll get it done, get it out, and give everyone else a chance to take a look at it and see if it passes the deadline.
Sounds like it's worth driving north just for that very purpose.
Yeah, really.
Ev-
And take some pictures.
I mean,
Hopefully it doesn't slide.
I looked at that email regarding the cannabis farm. That anybody contacted them, so I'll correct that error. However, that said, they're still in compliance until January 2021.
Even the lighting portion of it?
Legal pre-existing site, they had until January 2021 to come into compliance with those code sections. I do recall that I talked to that particular farmer about the complaint. And I thought there was some understanding that it would be useful to see some of that remedied, so I'll follow back up with that.
I couldn't tell much from the picture because
Oh, what
I
time?
see a lot of, well, no, I just see a lot of lighting around this county that would probably look just like that, so I'm just curious. I have to go there at night.
It's a big it's a greenhouse that's just got a bunch of fluorescent lights in it.
They think of a Viz Queen 10 with a big white gas lamp. Is kind of what it is.
It looks like it has an opaque sort of cover to it.
It's like that greenhouse fabric that allows light. Plastic,
Clear
Viz
plastic.
Queen I call that. I don't know if that's a cool term, but that's what we always
6
call
gold
it.
clear plastic is all.
But many of them, even the pre-existing ones, took the code changes to heart. And for instance, the Mons farm, they have night lights. They have the 24-hour greenhouse. They've also put a shade on it. You can't see it from
Do
the
you have any
outside.
other kind of greenhouses over there? There's the green greenhouses? Yeah.
Well, it's funny, because I was just thinking about that, because just up the road from that farm is my house. And I used to have a huge greenhouse that would light up in the morning, early in the morning for the chickens. And then it would light up, later on in the evening, but it wasn't all night. And so I think that was kind of the thing. I don't know anybody that has their lights on, for the most part, if they're on it at, up till 9 o'clock at night or whatever, I would assume that most people would be, yeah, that's fine, and then they go off. And it's not, 10, 11 o'clock at night, you got a big blaring.
There's not a dark skies ordinance in Methow Valley, or
There's not, people have been asked, kind of going through those things.
We have similar complaints in other parts of the county up on
about
Pine, about the lights.
the lights that the marijuana.
And in some cases, they were security lights, in most cases, and then I don't know the the husbandry of marijuana, but apparently for some reason, sometimes, yeah, I'm under light 24 hours for whatever purpose. And that's generally when we get the complaint, because it glows all night long. Some of the farmers, again, have taken steps to mitigate that. They put in,
Well, that would be the best thing to do from the get-go. I just think about the whole light situation everywhere, and I have a complaint I'm going to file here soon on a particular light along the highway that is north of Mac, that is worse than any of these lights that I hear. And it's along the highway.
I still occasionally swerve to miss the head at me. They're on 97 until I realize there are actually two lights perfectly spaced
Yeah.
on the shed there alongside
right.
the road.
Yeah, there's,
You'd think after 12 years of driving, I'd have the hang of it, but
because in the, there's a lot of talk, there has been a lot of talk about dark sky. I'm just curious about that. That would be an easier one to enforce if it was a dark sky ordinance in the county.
It's like that.
Flash to
Frontage
everybody.
road at Tonasket, just past Big Truck Shop.
Yeah.
You know,
Yeah.
we've actually had people
Oh, yeah.
drive off the road because that frontage road is.
You don't realize that there's a road.
They're trying to get on the right side of the car that's coming on the road.
So the little bit of an issue with that would be is that it would depend on timing, because we have I think it's the largest or best or nicest outdoor skating rink
Mhm.
in the state.
Well, wait.
And it produces so much light. It's unbelievable.
It is.
I mean, it is
Unbelievable.
like a beacon in the night.
I used to live
So-
right above it.
Yeah, so, you know, I mean, those,
That's, I think that the youth facility, the athletic facility will be there for summer.
I don't know. It seems like that because you got ice, it just reflects everything. I mean, it's bright. But-
Well, anyway, so much bigger.
Okay. Commissioners, one thing that I've stepped over, back under the banner of comprehensive plan, under your zone code review, we have the amendments for the lower Methow. We've already now conducted the public hearing for your multifamily amendments. Another that we have discussed that is anomalous on many different levels is the lot size in your neighborhood commercial zone. Your neighborhood commercial zone is that which we put over all of the unincorporated towns and villages, landlords, as you would call them in GMA speak, which allows a 5,000 square foot lot. Now, part of that, as I recall, part of that discussion was to avoid legal pre-existing or legal non-conforming, as it was called at the time, challenge in some of the more developed landlords. You have actually in your code allowances for legal pre-existing lots. You essentially do with them what you can do under the banner of public health regulations, as long as you reform legally at the time in compliance with the rules in place. Some of the landlords, there's absolutely no way you could possibly put a 5,000 square foot lot in place. We had,
New and. Yeah,
Pardon?
new, yeah.
you know, Wakanda as one example. You have several hundred acres of open land.
So what kind of lot sizes would you go to around those areas?
If you went, where we're talking interim controls, we could take it to an R1, which is generally a transition zone. However, I think we need to look at each of the individual landlords to see what they're really capable of. You know, Malott obviously is remarkably different, and it's a landlord. What is in place to sustain it? If there is some water system in place, if there are some community systems, the ones that in all cases they probably need to be pulled back to the existing town plants. But in the interim, we could take about 30,000 lots off the books, potential lots off the books, simply by moving them into R1 as a transition holding zone.
No, I agree.
I
They
think
have
it's
to be
good.
looked at because, I mean, if they're putting a septic, if they have a septic system on each one of those 5,000 square foot lots, and
You
are
couldn't,
they sharing wells on the lot?
couldn't do it by state
In a lot,
regulation.
I'm not sure. They'd have to if they had septic systems on each one
Yeah,
of those
I
lots.
didn't
You
know
couldn't
what
have
the
a well
situation
there on each
I'm
lot
wondering if
and
anybody's
septic.
looked at that decision.
5,000 square feet is actually on Ellenberg. That's residential high density.
That's in.
Residential low density is a 7,000 square foot
That's the
lot.
smallest lot.
Of course, that's on city water, city sewer.
Oh, city water, city sewer, right,
Yeah.
yeah.
In your, say, here's where the anomaly comes in. Your suburban residential zone, which is designed to be a transition zone between incorporation, city limits, and rural, where there's the availability, you have to have the availability of water and sewer to get suburban residential. That's an 11,000. At any rate, it's over twice the size of the lot size that's allowed in your neighborhood commercial. The other option we could take, and keeping in mind you don't have to necessarily amend them all out in one ordinance. We could take and look at the surrounding zone, look at the actual town plat, take the town plat and put it in R1 as a holding zone and just revert the rest of it to whatever the surrounding zone is, R5, R20, whatever.
Yeah.
That, more the question, do the commissioners want us to move ahead with that?
I think
interim
we should,
control?
because I think that's gonna come into your planning, your WRIA 49 planning stuff.
That's part of the calculation there, and it just in Wakanda alone, it was 10,000 lots or something.
Really?
Yes.
It's pretty
It's
remarkable.
astronomical.
Potential.
Mm-hmm.
Potential, not existing. Commissioners want to move ahead with, I'll come up with a methodology in front of you.
Unless the village wants to come up with a capital facilities plan and fix
Kind of
water and sewer.
Water management.
Well, you know, reason. I mean, then, that's body wants to create, speak, contain community, you can do that. Ask for the zoning, demonstrate that you can provide those compliance with the comprehensive plan. Do we want that sort of thing wherever? And that's part of your process. You can run them concurrent with the subdivision. There's a process for that sort of thing.
Yeah, they have to be places where there's some demand, I mean, attraction to have that development occur, like, you take Manson is a on Lake Chelan, but there's a lake there, and they have a commercial district, and they have water provided by the irrigation district, and they have sewer, and they grow, and they still are a village, so they don't have government.
But Malott has some water companies that, if they wish to, could theoretically convert some of their water.
My guess is they want to go below.
I've heard no compelling argument for a lot of development in Malott, but,
You get building permits in the lot?
Not much, no.
of interest to the, I think you asked the question, the annual review for the school / marijuana processing plant is this Thursday at 9 o'clock. They've indicated they probably won't participate in that process. So,
The permit holder? The permit holder? I speak over.
leading me to conclude they've thrown their hands up. So.
That idea?
We're done with your agenda, Commissioners.
We got two from them.
Your draft resolution,
There is, I need to approve this, agreement I
And
just
then
got
I'll
for public
email
services
you.
grant.
Yeah, I'd like to be able to get it tomorrow.
What's, well, I had a question, Public Works had a question about, to get in the proper time frame for that last $2,300 to be billed out for the grant. When do you need a bill by?
Today or tomorrow morning,
Okay,
because we're paying bills for a check on the 26th,
okay,
and that's the last day of the month that we're paying checks.
okay. So, could you call down to Public Works, see if we can get a hold of Gary? And tell him that you need that to, tomorrow morning?
Okay.
I move to approve the public services grant contract with Department of Commerce and authorize the chair to
Second.
Motion, second discussion.